dated September 16th of 2025, which says, lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making, quote, an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Close quote.
Lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. That is a direct quote from a court order signed on September 16th, 2025. Not a suggestion, not a guideline, a court order. Signed, entered, binding on every attorney in the state of Utah versus Tyler Robinson. Now hold that order in your mind. Picture it sitting on a shelf. And then picture a prosecutor going on Fox and Friends anyway. That is the gap this video is about. Not the politics. Not the case itself.
Counsel suggested that this is not the case. This is, Mr. Robinson versus Mr. Ballard. That's not what's going on here. This is a case about Mr. Robinson's constitutional rights, his presumption of innocence, and whether the violation of 3.6 requires various types of sanctions. That is this case. It's not a different case. Thank you.
Thank you, Mr. Novak.
The gap between what the order says and what actually happened. Because in a Utah courtroom on the morning of this hearing, defense attorney Richard Novak walked to the lectern and laid out what he called a media tour
of the prosecution team with respect to the decision for Mr. Ballard to go on what I will call a media tour is central to not only the core question of whether there's been a violation of the court's order, but frankly, the egregiousness of that violation.
And that phrase, media tour, is the kind of phrase that sounds almost boring until you understand what it means in a capital murder case with a jury pool that had not yet been selected. Before we go deeper into what the documents actually show, make sure you are subscribed to Case and Consequence, because we do not just cover the story, we follow the evidence. Here is the simplest version of the facts on the record. The defense filed a motion to continue the preliminary hearing. Inside that motion, they referenced an ATF report about ballistic evidence. The media picked up on it, stories ran, millions of views. Headlines that said the bullet did not match the gun. Then the Utah County Attorney's Office sent emails to media entities. Then Prosecutor Chris Ballard sat for an interview on Fox and Friends and characterized the forensic evidence.
Violation is what happened. The violation is extrajudicial statements that have a substantial risk of impacting the proceedings. Okay, and the two specific violations are Mr. Ballard's statements on behalf of the Utah County Attorney's Office. So the question really is, and I'm not suggesting that this is the case, but the question is, did Mr. Ballard go
on national television in a capital case with no jury yet seated? They violated Mr. Robinson's presumption of innocence. Novak's argument was not emotional, it was architectural. He walked the court through the statute. Utah Code Section 78B-6-309 says the court shall investigate the alleged contempt. Not may, shall. And Novak's point was direct. You cannot investigate what you
investigate, and this court can't allow the state to hide behind this notion that there's no good cause for disclosure under Rule 16A4. This is a classic situation where and a well-founded, not frivolous, serious allegation of a violation of this court's order in a capital case requires looking behind the curtain.
Cannot see. The internal communications, the emails to TMZ, the decision-making chain that led a sitting prosecutor to book a national media appearance, all of that is evidence, not gossip, evidence, relevant to the seriousness of the violation and relevant to what sanctions are appropriate. The state's response was equally structured. Prosecutor McBride stood up and made what is actually a coherent legal argument. Rule 3.6, subsection C, allows a
rule. Look at Rule 3.6, subsection C, and it states, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. That's the law. Let's go through it and apply it. A lawyer may make a statement, which Mr. Ballard did, that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity. Is there substantial publicity here? Yes. 22 million views in a day. We've covered that. Undue prejudicial effect. Is it undue prejudicial effect? Yes, it is, because it's a mischaracterization of the evidence. The report does not say that the bullet did not come from that gun, which is what the media was stating, right? That's undue prejudice.
A lawyer to make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. In plain English, if the other side caused a media firestorm by filing a misleading pleading, you are allowed to correct the record publicly. McBride argued the defense's characterization of the ATF report had two material omissions. One, the report did not just fail to identify the bullet to the rifle, it failed to identify or exclude it. Two, the bullet was identified as a .30 caliber class fragment, consistent with the .30-06 found at the scene. The defense called that exculpatory.
The state, as Your Honor knows, has a burden to prove a defendant's guilt beyond a reasonable doubt. The absence of evidence that a fact finder might find probative of guilt is itself exculpatory. So in a hypothetical case, there's no fingerprint evidence. The state doesn't offer any. That's exculpatory. In a hypothetical case, there's no confession. The state can't offer it. That's exculpatory. The absence of evidence is exculpatory. So the ATF's inability to match is exculpatory.
The prosecution called it inculpatory. The media called it a bombshell.
The Daily Mail ran a story garnering 22 million views on X in a single day. And the headline was, "The bullet used to kill Charlie Kirk did not match the rifle allegedly used by Tyler Robinson." Okay, the bullet did not match. Major networks throughout the country and even throughout the world picked up this story and echoed this statement that came from defense counsel's pleading. I don't lay that blame on the media. That's accurate reporting of what the pleadings stated and a reasonable inference.
And 22 million people on X read a headline that said the bullet did not match the gun. They violated Mr. Robinson's presumption of innocence. Now, here is the question that turns this from a legal dispute into something larger. If a prosecutor can unilaterally decide that a media frenzy justifies a national television interview about forensic evidence in a capital case without first asking the court whether that exception applies, then what exactly does a pretrial gag order accomplish? Think about that carefully, because the answer to that question does not just affect Tyler Robinson. It affects every defendant in every high-profile case where the media cycle moves faster than the docket. What is the order worth if the party bound by it gets to grade its own compliance? Novak addressed this directly. he told the court there was a third option the prosecution never took.
We would like you to consider amending your filing. They could have done that. Neither of those things happened. Instead, what they did was they drafted an email and they sent it to media entities like TMZ, and they scheduled an interview for Mr. Ballard with Fox and Friends, where he characterized it extrajudicially.
Before going on Fox and Friends, before emailing TMZ, Ballard could have walked into that courtroom and said, "Your Honor, we believe the defense has mischaracterized a forensic report, and we believe the media coverage is creating a prejudicial risk. May we respond publicly?" That hearing would have taken an hour. The court would have decided, and whatever happened next would have been judicially supervised. That did not happen. Instead, the defense team stood before the same court and said, "We receive media inquiries every single day, and we never respond, not once, because to do so would be a violation of Rule 3.6, and there is no exception that applies to our situation." Two sides, same media storm.
Mr. Robinson's defense team, and I've said this before, has strictly adhered to the principle that we will have no contact with any media and we will not make any statements to any media entity of any type. And in the same way that Mr. Ballard apparently was getting this influx of media inquiries, so are we every day. And we never ever respond at all, because to do so would be a violation.
One responded, one did not. They violated Mr. Robinson's presumption of innocence. The court took the matter under advisement. No ruling from the bench. A written decision was scheduled for June 1st, delivered by WebEx. The evidentiary hearing, if granted, was penciled in for June 12th. The judge's question to both sides was precise. If I grant the hearing, how long do you need? Novak's answer was honest. It depends on how many people were involved in this decision. If it was Ballard alone, one witness. If there were team meetings, emails, coordinated strategy, then the hearing gets longer. He used an analogy. You have to see what is in the soup before you know how long it takes to make it. The state's answer was simpler. Half a day, one witness, Ballard. Cross-examine him and move on. What neither side answered, because no one asked it directly, is the question that sits underneath all of this. Not whether Rule 3.6 subsection C was technically available, but whether the prosecution knew before the interview that their response might be a problem and went ahead anyway. Because Novak introduced an email from Ballard to the defense, attached to attorney Stacy Visser's sworn declaration, in which Ballard himself argued that publicly filing the ATF report would be a violation of Rule 3.6. He used the phrase end run. Filing a forensic report in the public record would be an end run around Rule 3.6. That email exists. It is in the record.